The petitioners of the firm believe that he has been able to prove his case in the 17 sittings that have been held so far. Even though Mr. Mahama insisted on the Election Commission chair testifying, he believes his case has been fortified with the respondents not adducing any further evidence. In his closing address, Mr. Mahama argues that his interpretation of using the figures as declared by the Election Commission chair on December 9 to determine if any of the candidates met the constitutional threshold of 50% is the only option available to the bench. Paragraph 4 of his closing address reads, "Neither the answer of the first respondent nor the amended answer of the second respondent deny the declaration made by the chairperson of the first respondent on December 9, 2020. What respondents purport to do is to attempt to explain away what the chairperson of the first respondent, Mrs. Jen Mensah, announced as inadvertent error. Without evidence, however, the court has no basis for even beginning such possibility." He further points to the court that the burden of proof imposed on him by the Constitution has been discharged. This, he explains, was as a result of the Electoral Commission admitting to facts that are material to the petition by not responding to their request to admit facts. Lawyers for the petitioner states that Order 23 Rule 3 Clause 2 of CI 47 provides that where the party on whom the request is served fails to serve a respondent as required by Sub-Rule 1, the party shall be deemed for the purposes of the cause or matter only to admit facts or the authenticity of the documents mentioned in the request to admit. On the basis of this provision, Mr. Mahama concludes that he has proven that none of the candidates obtained the 50% of the total valid votes cast. Paragraph 27 of his closing address partly reads as follows. The admission by the first respondent of averments in paragraph 16 of the amended petition and paragraph 13 of the witness statement of Asiedu Nketia, which paragraph 9 of the request to admit facts also seeks to reflect, definitely leads to no other possible conclusion of the fact than that, based on the data contained in the declaration made by the chairperson of the first respondent, Mrs. Jen Mensah, no candidate obtained more than 50% of the valid votes cast. But lawyers of Nana Akufo-Addo and the Election Commission say Mr. Mahama has not properly invoked the special jurisdiction of the court as far as an election case is concerned. According to them, the instant matter has not met the threshold established by law for the invocation of the special jurisdiction of the court to entertain an election petition. Paragraph 25 of Nana Addo's closing address, for instance, reads, "It is very clear on the face of the petition and indeed evidence of Mr. Asiedu Nketia in particular that the petitioner is not in court to challenge the validity of the election, but rather that the case concerns the performance of the functions of first respondents and its chairperson pertaining to the declaration of the presidential elections. This shows that the petition is not an election petition properly so called." The respondents have also stated that the petitioner has not been able to prove that none of the candidates obtained more than 50% of the total valid votes cast. They expected the petitioner to adduce cogent evidence to establish the serious allegations leveled by him. Nana Addo, in his closing address, explains that the claims of the petitioner were countered during cross-examination. Paragraph 48 of his address reads, "Petitioner has made much ado about nothing of the fact that in announcing the total valid votes cast, the chairperson of first respondent stated a wrong figure of 30,434,574 instead of the actual total valid votes of 30,121,111. This error and the effect thereof have been resolved by the cross-examination of Asiedu Nketia. The Electoral Commission has also, in its closing address, insisted on the transparency and integrity of the 2020 polls.